Right, I will get started on time. I'm sure we'll have a few more joining, logging in, solving the riddle of WebEx as we get kicked off. But good morning, welcome. Thanks ever so much for joining us. I'm Jo Martin, a partner in the employment team at Womble Bond Dickinson. I'm here with Karen Plumley-Jones, a professional development lawyer in our team. And usually we do these seminars regionally and in person, as many of you will know. And it's a shame we're not doing that. No coffee, no bacon rolls. The upside, however, is that we have our HR community all in one place this morning, which is marvellous. So thank you very much for joining us. We really appreciate that. We're going to look at key areas to assist you in your roles, following the format that we usually do. So an area of focus first, and then looking at recent case law and employment law updates that you need to be aware of. So I'm taking the focus area. It won't surprise you to hear that's COVID. Possibly for one of the last times, we shall see. So COVID focus first, then Karen will be looking at the recent cases and employment law developments. So a few points of housekeeping just as we get started. We've gone for forcible muting, I'm afraid. So everyone's muted for this webinar. Clearly there's always a dog, there's always a builder or just some random buzzing. So we've got everyone on mute, but we do have the chat panel and the Q&A panel. I'm sure everyone's quite familiar with this now, but if not, over on the right of your WebEx screen, you should be able to see a Q&A and a chat option. Any questions that arise at all, please put them in the Q&A box. We'll come to those probably at the end of each section. And we're recording the session as well. So if you can see notification of that, great. It's being recorded. Once it's downloaded to our systems, probably tomorrow, we will send it around to all attendees. So anyone with colleagues that wanted to come along that couldn't make it, please feel free to share that. We'll also have polls from time to time. Kind of the equivalent of having a raising of hands if we were all in person, just to see what our peers might think on a particular issue. So we'll be doing that. And again, when we do a poll, it will appear on the right of your WebEx screen. So just as a quick tester now, I've got a first poll to start. I've got Crystal, our events assistant in the background, who hopefully, here we go. So quite a short time limit for this one. What's the first thing you're going to do when lockdown ends? So if you open up the polling on the right of your WebEx screen, and start voting on what you're planning to do at the end of lockdown. And we should see how the polling works. So those of you who've had a strong coffee and can tackle the tech, I think that's the time limit up. Yeah. Haircut hasn't performed quite as strongly as I thought it might. But yeah, rightly, family and friends are up there. So go to the office, 1%, fantastic. Thank you very much, everybody. So that's polling. So as I say, they'll pop up here and there. And I think we've all cracked that tech, so that's brilliant. Any issues with connection or hearing us, there's the chat function, which Crystal can see, so please let her know there. So as I mentioned, I am starting looking at some key employment law issues as we come out of lockdown. It's the end phase, and I'm going to take pleasure in articulating. We are talking about what we hope are final issues relating to COVID that in the HR community we have to be tackling. So it's nice to realise that we may not be fighting this beast for our entire professional working lives. It's coming to an end, let's hope. So part of that clearly is the vaccination system. And that's the point I'm going to look at first. Particularly the point, can employers require employees to be vaccinated? Can they insist upon it? So as we know, at the moment, key vulnerable groups have had or are getting vaccinated. Those over 50 are expected to be offered the vaccination by the end of April. The aim is that the remainder of adults will be offered the vaccination by the end of July. So until then, we've got coverage, vaccinated group growing, but it's not complete. So we are, as HR professionals, dealing with that issue over the next phase of this situation. Now, making a vaccine mandatory is untested in the UK, and I've got the first sort of proper poll, as it were. Crystal, if you wouldn't mind putting that one up now, please. It's an opinion, no right or wrong answer as such. Would you like to be able to make vaccinations compulsory in your workplace? What does your instinct say on that particular question? Would you like that in your workplace? So a few seconds left just to pick your answer there. Thank you. Right, the results should ping in, and hopefully you can all see them. Very interesting. No is in the lead there, but only just. There's a good showing for those that would like mandatory vaccinations in their workplaces and don't know, quite understandably, that's why you're here, is 7%. So let's talk that through. Though you can't legally force a person to have medical treatment in the UK. We are talking about an employer requirement, not making new law, but it's worth starting from the understanding that you can't legally force medical treatment in the UK. Also, employers can't buy it. There's no private market for the COVID vaccine at the moment. So that adds another shade to your considerations of this point. It's very new territory for employers, whether or not you can insist upon something like a vaccine. An interesting counterpoint is that in hospitals, it's rarely, if ever, mandatory for staff there to have vaccinations. It's strongly encouraged and incentivized for sure, but again, very rarely mandatory. So for an employment law perspective, and as I'm sure many of you are already intuiting and thinking about, there are risks if you were to make the vaccination mandatory. So let's say the employee refuses. You make it mandatory and they refuse. Could you fairly dismiss them for that? Well, as you know, if you've got a dismissal that's challenged, the tribunal will look at, was that decision by you as the employer in the band of reasonable responses open to you? Was it the statutory fair reason for dismissal? Fair process, I'm sure we can all do a fair process, but is it in all the circumstances reasonable for you to have chosen that for your reason for dismissing that person? Now, to prove that, you would need probably a risk assessment showing that there's a very, very high risk in your workplace, that let's say there's extremely vulnerable people in that workplace that need protection. And quite importantly, and the biggest issue here, I think, is that you'd need to show there were no other measures that could be taken, no alternatives for that person not having the vaccine continuing to be able to work for you. So it's very risky territory from a disciplinary and dismissal perspective. As again, you've probably already appreciated, discrimination rears its head with this one as well. So indirect discrimination is, as you'll appreciate, where a situation is made harder for a particular group of people who all share a protected characteristic. They suffer a substantial disadvantage as a group compared to the others. So here you'd be thinking about people such as pregnant women who are classed as clinically vulnerable, and it's not recommended, is the medical language, that they get the vaccine. So let's say you made it mandatory and a pregnant employee wouldn't take it because the medical advice said not to take it, and they were perhaps disciplined for that or dismissed or whatever, then that's, or simply the pressure of having to get the vaccination when they don't want to, indirect discrimination on the face of it. Can you justify it? As you'll know, direct discrimination, there's no option to try and justify it if you're taken to tribunal for that. But if you're taken to tribunal for indirect discrimination, where you've got this provision, criterion, or practice making life that bit harder for that protected group, then in theory you can say, well, yes, it is harder for them, but it was a proportionate means of us achieving a legitimate aim, which is the legal wording. We can justify what we did. Could you justify it in that pregnant woman scenario? Possibly, but again, as with the dismissal reasoning, could there have been an alternative you could have taken? For example, longer home working being supported, or a different type of role for the period at which the majority of others were getting vaccinated. It's going to be hard to show that you couldn't have found another way other than having that mandatory everyone must be vaccinated policy. You've then got staff who might have a medical condition, making it non-advisable for them to be vaccinated. Again, as you'll be thinking, well, then that could qualify as a disability. So reason arising from disability, again, you're getting into your discrimination territory there. Can you justify it? Same problems as before with showing a fairness of dismissal, justifying with requiring the pregnant woman to do it. What are the alternatives available to you? Did your risk assessment say it was really essential, for example? Some other points to consider on this would be age discrimination. All adults, the aim is to offer them the vaccination before the end of July, but that doesn't include young adults. Presumably the programme will continue thereafter, but for some months yet, there's not the option for young adults to get the vaccination. As I said, it's not privately available, so they wouldn't be able to comply even if required to. You've then got the sort of slightly juicier area of belief-related refusals. So You might recall recently there was a case around ethical veganism where an individual was so committed in every aspect of his life to the ethics of his veganism that it qualified as a belief that can be protected under the Equality Act. There is a school of thought that says because the vaccine is likely to have been tested on animals, then ethical vegans wouldn't want to take it, and their belief requiring them not to take it should be protected in law. But it's important not to assume that of any staff you know, for example, to be ethical vegans, because there's another school of thought which says it won't make any difference. If ethical vegans don't have the vaccine, that's not going to stop animal testing. So they're not going to refuse the vaccine. You might feel we're down a bit of a rabbit hole here, but really that's just an illustration to avoid a presumption of a belief-related refusal arising, because it's, as ever, slightly more complex than it might first appear. What about anti-vaxxers? If they don't want to have it because as the name suggests, they're anti-vaccinations or this particular vaccination, is that a protected belief? Well, this is an interesting one. And whilst I'm a big believer in free speech, I'll still try and be polite about this. But the test that's set out in the recent cases around what beliefs are protected and which aren't looks at the weightiness of that belief. Has it reached a desired level of cogency? Is it worthy of respect in modern democratic society? That's one of the tests, and arguably it isn't. Arguably it's just an opinion. Opinions aren't covered by the Equality Act in the belief part. But also in the recent case law, there's been a consideration of risk created for others by certain beliefs that people hold. And it's arguable that the anti-vax beliefs can cause risks to others because it could decrease take-up of a vital vaccine. So that's very much may not succeed as qualifying as a protected belief. So again, please don't feel like you would be held hostage by these points. Simply, they would require a bit of consideration if they come up in your organisation. So back to the practicalities of this. If you feel that in your organisation there is a need for mandatory vaccination policy, you won't surprise you to hear that the advice is start consulting. Talk to your employee body, be it through a recognised union or just the employees directly. And as and when you come to a policy, write it down, check it, simplify it as much as you can and get it written down so people know where to turn to with any questions, or just so they know what the position is. And the counterpoint to all this is that you do have a duty to create a safe workplace. So there is a duty upon employers to reduce risk in the workplace. And as such, you should be strongly encouraging vaccine take-up. You can do this, and hospitals do this by incentivizing staff groups. For example, the team with the most vaccinated, if it's really important to you to get to this point, could have some kind of prize. You might think, well, aren't we back into indirect discrimination territory there if those that can't get it for a sound reason aren't getting that incentive? But I think then you would be safer in terms of justifying that approach that you've taken. No, you didn't get a box of celebrations. Sorry about that. I hope you can understand why we've given one to the team where everyone's been vaccinated, because this is really important. And thus, I think risk of being sued for that is much lower. If there are any questions on this, as I said, please put them in the Q&A panel. I'm going to go through all the bullets on this slide and then we'll look at questions for this COVID area, but we won't miss any. And if we'll take a couple, and if there's more than we can answer on this session, I can always address those afterwards. So moving to testing of employees, which as society and workplaces are opening up, and we'll come in a moment to the actual timetable for that, but it's a way of creating and maintaining as safe as possible a workplace. As I mentioned, there is a duty to try to maintain that for your staff. So in terms of options, some employers qualify for their staff to use local test centres. I think all employers, it's recently changed. Karen kindly highlighted this for me yesterday. So employers of any size who've registered can get free lateral flow tests. There were going to be size related entitlements for that, but actually it's everybody now. Employers can pay for third-party testing providers, or you could train your staff to do it themselves. It very much depends on your workplace, what people would be willing to do and what you'd want to be happening based on your industry and environment. So your employees will want to know how you plan to approach testing in the workplace. what type of test is it going to be? When's it going to be happened? How regularly do they need to do it? And what will happen if they get a positive result? So do they have to self-isolate? What will the pay implications be? And really importantly, how will you store the data, the results? So won't surprise you to hear GDPR, data protection act issues flag up when you're holding somebody's health information because it's special category data. So be very careful with that. From a self-isolation pay perspective, I imagine people are fairly comfortable about managing that because this is not new. This dealing with people who are isolating and how they might do their jobs during and what have you. But again, if you're going to have to take a new approach or a different approach, consulting on that is advisable. Putting a policy together if you think it's going to help people get their heads around how you're going to approach testing and what the outcomes will mean for employees. If people refuse testing and sort of similar lines to refusal for the vaccination, it won't hurt to be sensitive about that, find out the reasons for it, consider the discrimination risks and alternatives, and keep an open mind. It's usually the best way to minimize legal risk is to take that sort of approach. So on a slightly different note, just looking briefly at the recent budget and what that might mean for employers. So we've got the furlough scheme extended to the end of September, as you'll all be aware. So when we originally advertised this seminar, we were going to be talking about the end of the furlough scheme. And as ever with COVID stuff, it changes very fast. And I don't think Karen's sort of slept for months because she keeps us all up to date with that, with the brilliant Q&As and all sorts. But right, we're extended to the end of September with the furlough scheme. From the employee's perspective, no change to the terms. They continue to get 80% of their wages for the hours that they've not worked that they usually would, capped at the familiar £2,500 per month. Businesses will have to contribute 10% of wages in July and 20% in August and September. To qualify for the scheme for the extended bit, which is 1st of May onwards, you need to have had that employee employed on the 2nd of March and sort of PAYE registered before then. Again, I think if you've operated the furlough scheme already, you'll be familiar with that aspect, but your key date for employment of that individual is 2nd of March. And for current furlough scheme users, that date was the 30th of October, that required employment date. So the budget also mentioned that there will be visa reforms to help highly skilled migrants come into the UK and work here. Apparently, the elite points-based visas will be available in a year's time, so March 2022. It includes elements such as those who've won international prizes will have a sort of fast track to qualifying for those visas. Companies who are establishing a presence in the UK will have something called a mobility visa. And we're expecting more information on that over the forthcoming year, and we'll obviously share that with you as we understand it more. And then the last key point that we noted from the budget was the doubling of the incentive payment for hiring an apprentice to £3,000. Now, a couple more points on the practicalities of the final to post-COVID era that we're in. You might have had, well, you will all have had, no doubt, staff working from home, but you may have had some of those staff leaving the UK from a sort of perspective of doesn't really matter where I am, we're all remote, I'm off home to Italy or wherever. So can you require them to come back to the workplace? How does that work? Now, the bit of law that's brought into play here is the contract between you and your employee. I'm sure invariably you have written contracts with your employees, but the degree to which anyone has formally varied those contracts to allow staff to work from home, I can't imagine. I don't know that many necessarily will have done. We all knew we couldn't go to the office. We all adapted to work from home, depending on our industry. Of course, not every industry could do that. So amending a contract verbally, I'm working from home, yep, fine, please do. That can be contractually enforceable, even though it's not written down, it's not legalistic in nature. A verbal amendment to a contract is enforceable in law. There's also the course of dealings approach, which is where two parties to a contract start acting in a particular way. Nobody queries it, everyone gets on with it for a sufficient amount of time that it's clearly a pattern. That's a valid way of amending a contract as well. So all fine, all well and good. That's what we needed to do. That's what we have done. But how do we unpick that? So what you would argue, if it's not been explicitly said at any point, which it probably has, because you probably talk to employees about when the office reopens, let's talk about how it's going to work. But you'd hope it's implied that it was temporary. So the first thing to do, I would say, is just have a look at how you've legally managed the working from home and where that person works and the kind of language you've employed in doing so. So anything that points to it being temporary will help you. Ultimately, it's a reasonable employer instruction to require your employee to attend the office unless you have permanently changed their contract to say that they do not work in the office, they work from home. Hence, checking that point first. It's unlikely that anyone has permanently changed employee contracts to that. And thus, giving due warning of when the office is likely to reopen and due warning of your expectations of that employee should mean that if they don't then turn up, so presumably move back to the UK in order to then be present in the office, it would become a disciplinary issue that you can validly take forward on disciplinary grounds. Clarity in writing is helpful if you've got some outliers and you think, oh, it's going to be tricky because I think that they've presumed they can do this forever and I don't really want them to. Start the dialogue as soon as you can. So you're making it clear that you viewed it to be temporary, and thus you'll hear soon if they dispute that, and then hopefully you can try and address that dispute with them. So looking at the dates ahead of us, so we've got vaccine getting to manage, as we've touched on, testing to manage, and we've got holiday timing to manage. So this is from the HR perspective, obviously, as society is opening. So in terms of holidays, from the 12th of April, as I'm sure we're all from a personal perspective hotly aware of, that's when we're allowed to leave home and sleep somewhere else and not stay local, as it were, with the own household in the UK. So that's 12th of April. So from the HR perspective, I'd say you're likely, if you haven't already, to get surges of holiday requests for that week, given it's Easter holidays for schools as well. The week prior is also Easter holidays for school, but you can't leave home. So that's an interesting one. I think some regions it isn't Easter holidays. I think it differs across the country. And then in the summer, once the society is fully open, clearly there will be a lot of pent-up holiday angst needing to come out. So planning and thought around how best to manage that is wise as soon as possible. In terms of the end of the government's roadmap, they're calling this step 4 because there will have been 4 sets of 5 weekly phases, which you may well be familiar with, but just to reiterate in case people aren't, there's a 4-week period for data to be gathered and assessed. And then presuming that the next bit of the roadmap is clear to go ahead, then there's a week's notice of that. So there was a week's notice of the schools opening, then we're in a 4-week period, and then we'll get a week's notice of the, I can't remember what the next thing is, you can sit on a park bench and, you know, with your coffee. And so those phases, they've got the 5-week gaps in between them, leading up to the 21st of June, at which it's expected that no further limits on social contact will continue. So this is the likely date of workplaces reopening, if they're the sort of ordinary workplace, if I can put it that way, where people have otherwise been able to work from home. Now, in terms of managing employees, how they feel about this, there's been a bit of press coverage this week about likely anxiety levels. And I'm sure we can, if you don't have an anxiety condition, you could still empathise with the great change of expectation and how your day will feel and management of families and all that stuff. So health and anxiety-based issues, I think, are highly likely to be common. Then you might have more practical and pragmatic issues. Say someone might have moved house, as we said before, with the not working near the office anymore, and there might be a little bit of fudging going on to try and make that work into the future. As ever, if you're not already, which I'm sure most on this call are, consulting and talking with the employee group is really wise. Just find out how they feel. Doesn't mean you're committing to accommodating everything that they might want into the future forevermore, but find out how they feel, talk about issues of concern, take ideas about running the workplace into the future. It's a really good chance to incentivize staff. Everybody knows what we've shown is possible, so let's not ignore that, and let's have a discussion about how it can work best for your industry and operation going forward. And on that note, pre-COVID, I would have spoken to a lot of clients about requests to work flexibly, or we don't really want to for this reason, by which I mean work from home, and you've got your 8 statutory reasons to say no, and frankly, if you weren't keen on the request, you'd shoehorn it into one of them. There's always that risk of indirect discrimination for having this policy of not encouraging working from home, negatively affecting those most likely to have childcare responsibilities, which remains the females. So that is still the situation. The law hasn't changed around that, but what has changed is the body of evidence that someone wanting to work from home now has to show how possible it is. So if you know that as an organisation you really don't want that to continue, it's worth having a good think about why that is and putting almost a business case together so that you don't just look anti working from home. So you've got a body of business related evidence as to why that's not feasible either completely or at the current level going forward, because I think the requests for it will be very confidently put from here on, because as I say, we've shown how it's all possible. So the last point I will go through relatively briefly is the childcare aspect. So thankfully, and I don't mean to be parent-centric at this point, but I think those who have children who are now back in school will, feel the elation that bubbles in my heart as I say this. They are back in school and, praise be. But it's not all plain sailing. Clearly, there's testing going on in schools, particularly in secondaries, positive test, back home again. Bubbles might be closing. It's not plain sailing. It is going to be a little bit dramatic for parents in terms of ability to focus on their day or attend work if there's somebody who's doing that for an essential worker, or just how the timetable of their day. So the flexibility that employers have already shown for parents throughout this pandemic and lockdown, I think is going to continue for a while yet to accommodate these isolations and bubble closures and what have you. So similar considerations as before, looking at being flexible around changes to duties, hours, looking at leave they might need to take, be it parental leave, time off for dependents, annual leave. And as I'm sure everyone is aware, it's another chance to incentivise staff, keep loyal staff, treat people fairly, not presume that female employees are likely to be carers, they're the ones going to be off in that situation. And I think it probably goes without saying, but disciplinary action around the requirement to not work because your child's been sent home isn't very wise, unless you think it's dishonest and the child hasn't been sent home. Clearly, that's an entirely separate matter. But again, I think people are quite well versed with this now. So that's a bit of a whistle-stop tour through the employment aspects of this last phase of lockdown, which I don't think I'll ever tire of talking about in those terms. So any questions at all on this from anybody?
We've had a few questions in, Jo, and mostly they centre around vaccinations and testing, which probably won't surprise you. No. So I'm going to start with a really interesting question we've had from somebody in the hospitality sector. And they've asked whether they can ask staff in advance if they're planning to have a vaccination so that they can publicise this to customers when they reopen. So, for example, they can publicise their COVID-safe policy and make a statement that all of their staff have been vaccinated or will be vaccinated when they're offered that opportunity. What's your view on that?
That's a wonderful question. And I think that also just underlines the difficulty of that sector in particular, which is one very close to my heart, and the hard work that's been going on for a very, very long time now to try to maintain these businesses and keep customers confident and get them back up and running as soon as possible. I think that sounds quite consultative in nature, which I like. That bodes well. It's probably obvious from what we've talked about until now that the suggestion that there could be a wrong answer to the question of are you planning to get vaccinated, that needs to maybe be thought about in advance. So I think you can have that discussion with your employees. You can make it very clear to them that this is a very sensitive matter, that they don't have to let you know. It's entirely up to them. But because of the nature of your business, it would be helpful if they would consider telling you. It's special category data under the Data Protection Act. So how you might collect that or note it down needs to be addressed in accordance with your privacy notice and your data protection policy. If you get 100% of your staff happily informing you that yes, they do plan to get the vaccination, and then confirming that they've had it, all of which, as I say, I think needs to be done without undue pressure or any sense of duress and in a very confidential fashion, then you would also need their consent in writing to publicising that. And I don't mean to sort of over lawyer it, but it's more because of the type of data we're talking about as much as anything. So presuming that everyone's happy and no discrimination issues whatsoever, or, coming up with everyone wants the vaccine, gets the vaccine, you would need probably a regularly updated consent to that being published, because that's sensitive category data about that person that's going to be up on a poster or on your website. So just be careful with it. But I don't know if you have any comments on that, Karen, but I think if it's done very carefully, I could see that working all right.
Yes, I agree with you on that one. And one quick question to finish your section, Jo. Can we take disciplinary action against an employee who refuses to take a COVID test in the workplace?
In theory, yes, but you have a lot of stages to be very careful with before you were to do that. I think you would need to find out why in a sensitive fashion, consider the discrimination factors. For example, I'm pregnant. I hadn't really wanted to tell anyone because I'm only 7 weeks or whatever, but maybe it's that, or I've been advised because of my lifelong medical condition that I shouldn't. So clearly disciplinary action following being told that, very unwise. But potentially, if you've got the reasonableness backed up by facts, so the risk assessment that's necessary to do it, and that you feel that you can support it being so important that disciplinary action is required, then it's not a blanket no to be able to take that route.
Thank you very much. Shall we move on then and have a look at some recent cases?
Thank you, Karen.
So I'm going to start off with Uber BV and others, and Aslam and others. And the main issue in this case was whether Uber drivers were workers or not. Now, the background is that there are 3 different types of employment status in the UK. So at one end of the spectrum, you have employees who have the full range of employment rights. At the other end of the spectrum, you have self-employed independent contractors who are in business on their own account and have very few employment rights. And then in the middle, you have this relatively new category known as workers. And they have some employment rights, but not as many as employees. So, for example, they have the right to paid holiday, they have the right to receive the national minimum wage, they can't be discriminated against, they can't have unlawful deductions made from their wages, and they have the right not to be subjected to a whistleblowing detriment. And the test for whether somebody is a worker is set out in the Employment Rights Act, and that says that a worker is an individual who works under a contract, whether express or implied, and whether oral or in writing, whereby the individual undertakes to perform personally any work or services for another party to the contract, whose status is not that of a client or customer of any profession or business undertaking carried on by the individual. And we've had a number of cases over recent years where individuals have said, no, I'm not an independent contractor, I'm a worker, or I'm an employee, and the tribunals have had to look at applying that test. The facts in this case were that, as probably everybody knows, Uber operates by means of a smartphone app, and passengers use that app to book rides. Drivers also have their own app. Drivers use their own cars and they can choose when they're available to take bookings. Uber exercises a great deal of control over the drivers, so it sets the fares, it imposes contract terms on the drivers, it penalises them if they turn down a trip or cancel one, and it uses a ratings system to control how the driver delivers the service. It also takes steps to prevent the driver and the passenger communicating so that they can't establish any sort of relationship. So a number of Uber drivers brought tribunal claims against Uber, and they alleged a failure to pay the national minimum wage, a failure to provide a paid holiday, and also whistleblowing detriment. Now, to be able to bring those claims, they had to show that they were workers. Uber said they weren't. They argued that the drivers were all self-employed, and Uber argued that it was a technology platform which enabled drivers to provide services, but Uber didn't provide the services itself. They were provided by drivers under a contract which Uber argued was between the driver and the passenger for each journey, and Uber acted as an agent. So when it came before the tribunal, they agreed that the drivers were working. Uber appealed, that went to the Employment Appeal Tribunal and then the Court of Appeal, and they both agreed with the Employment Tribunal. So Uber appealed again, and the case came before the Supreme Court.
the Supreme Court dismissed Uber's appeal, and it said that the rights that were asserted by the drivers weren't contractual rights, but they were created by legislation. So the tribunal had to interpret the legislation and give effect to the purpose of that, which was to protect vulnerable individuals who had very little say over their pay and working conditions. And the Supreme Court said that it would be wrong to treat the terms of the contract as the starting point when you're deciding if someone is a worker, because that was completely in the control of the employer. They could word the contract in such a way as to suggest that the individual was self-employed, and that would defeat the purpose behind the legislation. The Supreme Court held that the drivers were working for Uber under contracts with them, and that Uber subjected them to a very high degree of control as to how they carried out their work. And that meant that the individuals weren't in business on their own account because they couldn't use their skills to improve their financial position other than by working longer hours. There was a secondary issue, which is if Uber drivers were workers, when exactly were they working? And the Supreme Court said that that wasn't limited to time when they were actually driving passengers, which is what Uber had argued, but it included any time when they were logged into the app, when they were within the territory where they were licensed to operate as drivers, and they were ready and willing to accept trips. So what does this mean for employers? Well, first of all, looking at it from Uber's point of view, they're going to have to pay holiday pay and the national minimum wage to all of the drivers who claimed. And I understand that there are hundreds, if not thousands, of other claims by Uber drivers which have all been stayed pending the outcome of this case in the Supreme Court. So presumably those will all proceed now unless they're settled. And a result of that may well be that fares go up. So anyone who uses Uber may find that they have to pay more in future. Uber are very much playing down the consequences of this decision. They're saying that it just applies to a very small group of drivers who were on a particular set of terms and conditions back in 2016. But I think there are going to be far wider consequences than that. So there are certainly wider implications for other employers in the gig economy, because the Supreme Court was very clear that contracts are going to be much less important in future, and tribunals will focus more on the reality of the situation, bearing in mind the purpose of the legislation. So anyone who uses contracts with contractors would be sensible to have a look at those contracts and review them and see whether there's a possibility that the individuals are workers or even employees. And it's very clear now, not just from the Uber case, but from a whole line of cases we've had, that if the organisation exercises a great degree of control over how and when the work is done, then individuals are unlikely to be self-employed. The next case I want to look at is LA UK Limited and Galen, and the issue in this case is whether an employer can rely on the reasonable steps defence to harassment, where it's provided equality and diversity training, but that was around 2 years before the incident took place. So to give you a little bit of background to that, where you have a claim for harassment and the act that's complained of was allegedly carried out by an employee, an employer has a potential defence to the claim if it can show that it took all reasonable steps to prevent the harassment taking place. All reasonable steps will include matters such as having an up-to-date equal opportunities policy, making sure that employees are aware of the policy, and carrying out equality and diversity training. So I'd like to carry out a quick poll at this point, and the question is, if we could have the poll, thank you very much. How often do you carry out refresher training on equal opportunities and harassment? Please be completely honest about this. The survey is totally anonymous. Nobody can see who you are and how you've answered, but it'll be really interesting to see how often people do that at the moment. Okay, so we've got a range of different answers. It's fairly evenly spread apart from we don't do refresher training, which has the highest number. So around a third of people have said that they don't do refresher training. Thank you so much for your honesty. That's really, really helpful. And that very much bears out what I expected to be the case. So this is a really important decision for all employers. The facts were that Mr. Galen, the claimant, described himself as being of Indian origin. He joined ALE as a senior data analyst, and he was dismissed just under a year later for performance-related reasons. He complained that he'd been subjected to racial harassment by a colleague, Mr. Pearson, throughout the whole of his employment. There was an investigation which found that Mr. Pearson had made racist comments, and in fact, Mr. Pearson admitted carrying out racist banter, and he was ordered to undertake further equality and diversity training. Mr. Galen brought tribunal claims against the company, including for harassment, and ALE sought to rely on the reasonable steps defence that I outlined earlier. They relied on the fact that they'd carried out training, including harassment related to race, around 18 months before Mr. Galen joined the company. The tribunal rejected their defence and awarded Mr. Galen £5,000 compensation, and the company appealed. The Employment Appeal Tribunal dismissed the appeal, and they held that the training was stale, so ALE had not taken all reasonable steps because that would have included carrying out refresher training. The EAT said that when tribunals are considering the defence, they need to look at the nature of the training and the extent to which it was likely to be effective. And in this case, the company's training hadn't been effective because Mr. Pearson had made the racist comments. A colleague had heard those comments and hadn't reported them. And there were also 2 managers who'd been informed about the racist remarks who didn't take any action. So, what does this mean for employers? Well, clearly we know now that it's not enough to carry out equality and diversity training just for new joiners as part of their induction, or to do it every few years. And we also know that the quality of the training is relevant and that it has to be substantial. I think it's interesting to note that ALE is a fairly small employer, and the tribunal will expect more from a large employer. So particularly if you are a large employer, have a look at this case. There will be ramifications for you. But as a reminder, training on its own isn't going to be enough. You also need to have regularly updated policies which need to be communicated to staff. And you also need a culture where discrimination is very much not condoned. I think it's interesting that the Employment Appeal Tribunal drew an analogy between diversity training and COVID-19 vaccines. So they said that we're interested in how effective they are and how long they will last. I think it's another interesting point that comes out of this, which may provide a bit of a challenge to employers in the situation we're in with the pandemic at the moment. So where you have employees who are working from home or they're working in a socially distanced workplace, it may very well be difficult to get them together to carry out training in person, so you need to consider remote training. So the last case I want to have a look at is Kabelius and Kent Foods Limited, and this is very much a case rooted in our time, so it's all about a failure to wear a face covering. And the background of this is that under Section 98 of the Employment Rights Act, misconduct is a potentially fair reason for dismissal, and whether it's fair or not depends on whether the employer acted reasonably in treating it as a sufficient reason for dismissing the employee. And the starting point in misconduct cases is an old case called Birchall and BHS, where guidance was given that the employer has to believe that the employee is guilty, it must have reasonable grounds for that belief, and it must have carried out a reasonable investigation. So the facts were that Mr. Kabelius was employed as a delivery driver. The employee handbook required courteous treatment of clients, and it said that employees had to take all reasonable steps to safeguard their own health and safety and that of other people as a result of their actions at work. There was also a driver's handbook which required drivers to follow customers' instructions regarding PPE. Mr. Kabelius worked at the Basildon depot, and 90% of the work at that depot involved travelling to and from a refinery site owned by Tate and Lyle. As a result of the pandemic, Tate and Lyle required face masks to be worn at the refinery site, and visitors were issued with them on arrival. Mr. Kabelius refused to wear a face mask in the cab of his vehicle. He said he'd wear one if he got out, but not while he was in his cab. Even though 2 Tate and Lyle employees asked him to wear a mask, explained why, and referred to the company's rules. Tate and Lyle reported the incident to his employer and banned him from their site. The employer investigated the incident and invited Mr. Kabelius to a disciplinary hearing. He was dismissed without notice and brought a claim for unfair dismissal. And I'm going to run another quick poll now, if we could have that one up, please. Do you think this was a fair or unfair dismissal? Vote now. So roughly even split, 48% thinking it's a fair dismissal and 43% thinking it's unfair. I think that's a really interesting conclusion. In fact, the Employment Tribunal held that the dismissal was fair, and that was because Kent Foods had a genuine belief that Mr. Kabelius was guilty of misconduct. They'd carried out a reasonable investigation and they'd acted reasonably in treating the misconduct as a sufficient reason for dismissal. They said that another employer might have chosen to issue a warning rather than dismissing, but dismissal fell within the range of reasonable responses, and the employer had been entitled to take into account how important it was to maintain a good relationship with Tate and Lyle, but also Mr. Kabelius had insisted that he'd done nothing wrong, which caused them some concern about whether he would do the same thing again in the future. And they were right to take that into account, as well as the fact that it gave them a real practical issue. If he was banned from Tate and Lyle's site, he couldn't carry on in his normal role because 90% of the work from that site was for Tate and Lyle. So what does this mean for employers? Well, I should point out it's only a tribunal decision, so it's not binding, but it does indicate how the tribunal will treat similar cases. Although face masks obviously are compulsory for employees in some settings, such as shops and public transport, employers may need to conduct a risk assessment to decide if masks should be used in the workplace. And if so, obviously you need to tell employees that. If they are necessary, you need to be careful if you're going to enforce their use, because there will be some employees, such as those with physical or mental illnesses, who may be exempt, and you could face a discrimination claim if you insist on those employees wearing a mask. But if an employee is unable to provide a reasonable excuse for refusing to wear a mask when they're asked, that could be grounds for taking disciplinary action against them for failing to follow a management instruction. So let's move on to the next slide and have a look at what's in the pipeline this year. I'm just going to pick out a few of the more interesting developments. So the first one on the 19th of March, this Friday, the public sector exit payment regulations are going to be revoked. Those regulations introduced a cap of £95,000 on public sector exit payments, but the government carried out a review a couple of months ago and decided that the regulations had some unintended consequences, so they're revoking the cap. And what this new set of regulations says is that where an employer made a payment that was subject to the cap between the 4th of November and the 19th of March, they have to pay the difference between the amount that was paid and the amount that would have been paid without the cap to the employee or into a pension scheme on their behalf. But they have to pay interest on the difference, and the rate of interest is 8%. There are various increases in rates and payments that always come through in April. I've set out when those are happening on the slide. If you want details of exactly what the changes are, have a look on our website. We've got an employment key facts document which sets out all of the current rates. I would just mention the increase in the limit on employment tribunal awards that's happening on the 6th of April. So that applies where the effective date of termination is on or after the 6th of April. And the limit on a week's pay is going up to £544, and that's used for calculating basic pay and statutory redundancy payments. The maximum compensatory award is going up to £89,493, or 52 weeks gross pay if that's less. And the maximum basic award or statutory redundancy payment will be £16,320. I'll just mention as well the new right for workers, which is coming in on the 31st of May. So from that date, workers as well as employees will have the right not to be subjected to a detriment in health and safety cases. What does that mean? Well, it's easiest to look at an example. So if a worker refuses to go to work because their workplace isn't COVID secure and they reasonably believe that being at work would put them in serious imminent danger, and they're dismissed as a result of not going to work, they can bring a tribunal claim, whereas previously you had to be an employee in order to be able to do that. So if you could move on to the next slide, we'll have a look at some of the future changes. So first of all, Brexit. I think we're all expecting to start seeing the UK deviating from EU employment law soon, whether that's as a result of the Court of Appeal or the Supreme Court overriding ECJ case law, or whether Parliament legislates to change UK law that's derived from EU law. There are some limits on what they can do, which are set out in the Trade and Cooperation Agreement. So the UK can't reduce the level of protection for workers in a way that affects trade or investment between the EU and the UK. And if it does, that can lead to tariffs being imposed. So I think that means we're more likely to see minor changes than the abolition of an entire law. The other items I've put on that slide are all things that we've been promised at some point that haven't made it through to start the parliamentary process yet. So it's likely we'll see some changes to non-competition clauses, so restrictive covenants. There will be some measures relating to workplace sexual harassment, and I think in view of the debate that's going on at the moment regarding women's safety, I think that's going to come back up to the top of the agenda. And there are some changes to non-disclosure agreements proposed, which we're also waiting for. And lastly, there were a number of proposals that were due to be set out in an employment bill, which we've been waiting for over a year now, so hopefully they will come through soon. I mentioned we've got an employment key facts document on a website that gives you details of all of the current rates. We also have an employment law timeline which sets out all of the changes that we're expecting and gives you dates and more information on those, so do have a look at that. So that brings us to the questions and answers.
Thank you very much, Karen. We've had a real peach come through. There's some great questions, and thank you so much, everyone, for those. We won't be able to get through them all before 11, and we don't want to keep people after that time, but we will try and come back on some of those if we can when we send around the recording. Somebody has said they have a colleague who's refused to wear a face mask in customers' homes and suppliers' premises. They've refused to follow the lone working process, presumably around safety behaviours. He claims a medical reason but refuses to give us any detail. He's currently suspended from work. I don't know if that's a health and safety named suspension or a disciplinary suspension. Do you have any initial thoughts on that and the issues that raises, the many issues that raises?
Yes, absolutely. It sounds like a very complex situation. And not something that I can cover comprehensively in the time we've got. But I suppose the starting point would be to try and find out why he's refused to do these things, in particular wearing the face covering, and why he won't follow. I think you mentioned a lone working policy.
Yeah.
So I would want to dig into the reasons for that and see if we can find out why. And if there is a genuine reason, can that be dealt with in some way so that he will then follow the policy, or can we make an accommodation if there's a genuine medical reason, for example?
Yeah.
I think you said as well that he was refusing to cooperate in relation to medical records.
He's just not giving the medical reason. He says it's for medical reasons, but not saying why or what those reasons are.
So it's worth seeing if you can get consent to get information from his GP, or if you have access to occupational health services. I think a referral to OH would be really helpful to try and find out what's happening there. And then depending on the sort of information that comes out of that process, if there is no genuine reason, then it would be open to you to consider taking disciplinary action. Jo, you may have some more thoughts on that one.
No, I think you've covered tons. That was very comprehensive. As Karen says, the referral to the doctor, if he's not giving you the medical information, he might be reticent, but perhaps in your template contract, it has, as many do in there, the commitment that they will agree to have a doctor's assessment if they're not well enough to work, or words to that effect, which might help you on this one. I'm glad to hear he's suspended, simply because you presumably have the lone working policy to keep him safe and others safe, and if he's not following that, I mean, that's one of your problems, I appreciate, but he can't be working safely. So to protect yourselves, that is the right thing to do. But yes, I mean, you could spell it out for him if you suspect it's just an opinion-based view on wearing masks or something. You could say, we need the medical information. If we don't get it, we may have no choice but to treat this as a disciplinary matter, so that he can see exactly what you're up against. But no, that's a tricky one. And one final quick question, Karen, if I may. With regard to refresher training, someone's asked, how often do you recommend that that's done, given the case around the need for it to be refreshed? What kind of timing would you say was wise on that?
That's a really good question. It's actually quite a difficult one to answer, because the EAT didn't give us any guidance other than in that particular case saying, well, 18 months clearly wasn't often enough. So I think a lot of it is going to depend on the employer, how large they are, but also on the type of training that they give. So if the training is very good quality and they know it's effective because they haven't had any grievances, haven't had any tribunal claims, then they can maybe carry it out less often. But I think as a very, very rough rule of thumb, maybe look at making sure that you carry out some sort of refresher training at least once a year. You may need to do that less frequently or more frequently, depending on how effective you can see that's being in practice. Jo, do you have any thoughts on that?
No, that's great. Thank you, Karen. And one very, very quick final question. An individual has stated that she will be unable to return to the office when we reopen due to caring responsibilities for her mother and toddler. We've suggested she applies for flexible working, but she does not want to do this. Now, presumably it's clear in this organisation that that person would otherwise be required to return, so that the temporary nature of the current home working has been made clear, and she's effectively asking for that to continue. You're entirely within your rights to require that to go through the flexible working process, not least because that allows for consistency between her and others. It allows you to manage who else might be asking for it. So from your perspective, you can have consistency around who you have in and when. I would explore the reason why she doesn't want to do it. If she can't be bothered, then you can say, well, you need to, otherwise this can't progress. But it might be that there's a reason that we just don't know yet that puts some colour to this that might be helpful to know. So I'm afraid we can't take any more questions this morning because I don't want to make anyone late for an 11 o'clock appointments they might have. But I know there are many more questions on our list than that. So thanks for your patience, those who we weren't able to come to, and we will try to do that. When you log off this call, there'll be a quick feedback WebEx-based form. I'd be really grateful if you could please fill that in. That helps us improve and do more seminars of interest to people in future. And then on that final slide, there's a couple more webinars we have coming up for the diary and access via our website to book a place. So thank you very much for attending this morning, and best of luck everyone with the next few months to come. Thank you.
Thank you. Bye-bye.